My Lords, I rise to speak to Amendment 75 particularly, but the whole issue of automated decision-making is extremely worrying. As we've gone through this bill, I've been desperately hoping that some of the most repressive bits are actually a negotiating tactic on the government's part, that the government in the negotiations, perhaps before the report stage, are going to start saying, we'll take out this really, really nasty bit if you let us leave this not really quite so nasty bit in. Now, I feel that this particular issue is one of those really, really nasty bits. I would also like to thank Liberty, who has worked incredibly hard on this bill and drawn out the worst, the really, really nasty bits. Under the Data Protection Act of 1998, individuals have a qualified right not to be subject to purely automated decision-making. And to the extent that automated decision-making is permitted, they have a right to access information relating to such decisions made about them. The GDPR clarifies and extends these rights to the point that automated decisions that engage a person's human rights are not permissible. And this could include being subjected to unfair discrimination. The Noble Lord Clement Jones used the phrase unintended discrimination, for example, detecting sexuality or diagnosing depression. The rapidly growing field of machine learning and algorithmic decision-making does present some new and very serious risks to our right to a private life and to freedom of expression and assembly. And such automated decision-making is deeply worrying when done by law enforcement agencies or the intelligence services, because the decisions could have adverse legal effects. Such processing should inform rather than determine officers' decisions. We must have the vital safeguard for human rights of the requirement of human involvement. After the automated decision-making results has come out, there has to be a human who actually says, yes, this is reasonable, or it's not.